This is the introduction to managing protests and appeals. We'll touch a little bit on the contract piece of this, but a lot of the presentation is going to be around protests and appeals of solicitation and solicitation awards. As I am the procurement official for an agency, it's also going to come from this perspective that I have, because within Colorado, we specifically handle the protest responses at the agency level. It doesn't go to our central office and it doesn't go to the AG's office. But a lot of these concepts that I'm going to talk about are applicable really wherever you sit within your state and within your agency is. So, disclaimer.
Standard. I think you guys are going to get sick of seeing these disclaimers. But yeah, these opinions are expressed by Chelsea and myself. They are not official statements of the state of Colorado. So you all saw it.
So this is Introductions to Protests and Appeals. So we're going to talk through what is a protest, what's the kind of protest process and appeals process that it looks like at the state of Colorado. And we'll also kind of, as we go through this, talk about some of the strategies that I have found in handling protests and appeals. And then, assuming there's time, because I tend to talk a little fast, don't be afraid to raise your hand and tell me to slow down. We'll go through some protest scenarios. If folks are interested in having a discussion, I'll ask some prompt questions. And also, as we go throughout this, feel free to raise your hands, hit those push-to-talk mics, jump in at any time, or send a question in the chat or the app that Megan can ask of us.
So we'll just do a quick word on the Model Procurement Code. So during this presentation, we're going to be giving you protests and appeals from the perspective of the state of Colorado. And the state of Colorado does base a lot of our stuff on the Model Procurement Code. So it might seem really familiar to those of you who also have a state that follows a lot of the Model Procurement Code. Just kind of putting it out there. We don't talk too much about it specifically because we're gonna say it from our perspective, the state of Colorado. But it is there, and it might sound familiar to some of you.
All right. So there's also the idea of even why do we allow protests in the first place? And I think Megan mentioned this again earlier today, that hopefully you come away from this presentation not being scared of protests and really not seeing them as a bad thing at all. Because the reason we even want to let protests happen and why we write it into our model code, why the states have adopted it as within their own statutes as best practice, is we work in the public interest. We are public figures. We want our constituents, our citizens of our states, to trust the state procurement process. So we have, I think we heard from Arizona earlier, a great citation from a case from the city of Phoenix. So I am going to read this because I think it is really important to understanding why we care about protests, again, in a positive way, is although the courts generally will not disturb an honest exercise of discretion, it has been said that they will intervene to prevent the arbitrary rejection of a bid when its effect is to defeat the objective to be obtained by the competition. So you've already heard a lot today. We heard from Keith on you really want to make sure that as you're going through the process and what you're allowing and what you're not, doesn't undermine the whole purpose of the procurement process in your state.
So where do you look if you're trying to figure out how your state handles the protest process? Obviously, statutes, regulations, policies that your state has, and then the solicitation documents themselves. In the state of Colorado, you can find our protest process in the Colorado Revised Statutes, section 24, 109, 101, and 201. So take a look at your state, see where your direction comes from, but you know, it can be spread and it can be pretty varied depending on where you are. Okay, and then who can protest? There's two main elements of who can protest usually, at least in our state, probably in most states. There's who can protest and what are you protesting about? And in the state of Colorado, there's two concepts. The first is that of an aggrieved party. So you have to be an aggrieved party. You have to have actual or prospective bidder, an offerer, or a contractor who believes that he or she has suffered a denial of legal rights in connection with the solicitation or award. So the general public in Colorado cannot protest. They don't have standing. And then what can you protest about? And again, in the state of Colorado, the material issue is what you're limited to really protesting about, and that we have some information about what is considered a material issue here. You can have issues that are not necessarily material if there's a certain, like if it reaches a certain level that those issues together would prejudice the outcome of a procurement. So material issue is the general standard, but it can be, there's some discretion there depending on whether or not something actually prejudiced the process.
Yep. And there's no like specific number of like immaterial issues that you could reach to say, okay, now it's material. It still would have to have, the number of immaterial issues would still have to have an effect on the result of the solicitation and the award. So the aggrieved party, I'm gonna tell some stories in here just to give some real life examples from Colorado. So we only adopted the aggrieved party standard 7 or 8 years ago probably. And there was a situation where the Colorado Department of Education, they do a lot of solicitations for the good of our different counties who run the different schools in their counties. And one of the counties didn't like the results of a CDE solicitation. They're not a bidder, not a prospective bidder, and they protested. And we didn't have an aggrieved party statute that says you don't really actually have an interest in this under the procurement code. So CDE had to deal with that protest. So it's definitely important if your state doesn't have an aggrieved party statute, which I'm guessing most of us do now, but it's definitely something to look into because it can really derail one of your solicitations. So one really important thing to know when you get a protest, either if you're internal to an agency, in internal counsel at your agency, or at the AG's office, is you want to make sure you manage your expectations of how you're going to handle the protest. We all know this, but we have a responsibility for due diligence. We have to make sure we are taking our time, reviewing all of the materials, not just what the vendor gives us. We have to go back and look at the procurement file to research everything. And this is really important for your clients, or the way it's written here for me, for my program staff, because I'm building trust with them and I'm maintaining that trust. They know I'm not just going to review what the vendor gave us. That's of course written in their favor and say, yep, it sounds like you screwed up, so I'm going to uphold the protest and you got to start over, or we got to redo this whole thing. But they also know that if there is something that's been messed up that we need to know about, we're going to find it so we don't end up in this situation again, so we can fix it, which is why not every win in a protest means that you get to deny the protest and tell the vendor to go away. A win can look like upholding the protest and then fixing and improving our own processes. I tell my staff all the time, we don't write our solicitations, we don't do the process to avoid a protest. We do them the right way. And if there isn't any, if we've done them the right way and there's not any flaws, and if we get a protest, we're good. There's no issues. But if there is an issue, I want to know about it so we can continue to maintain that public trust as well. No situation is going to be perfect. There are potentially going to be issues that you find. That doesn't mean they're material. That doesn't mean that they're the issue raised in the protest that I'll talk a little bit about later. But it's still really good to find those out and to know the weakness of your case, weakness in the process, so we are continuing to improve throughout our entire careers in the procurement space. So just some general kind of do's and don'ts when you're getting a protest. Do, as I mentioned, take your time, make sure you've read the protest itself thoroughly and any exhibits that the vendor submits, either because it's relevant information or it may not be relevant information. But if you don't read it thoroughly, you might not know when you can say, yep, we don't even have to deal with that. If you are not counsel and you want to involve your counsel as early as possible, make sure you do that with enough time. I'm sure, again, that you get the Monday morning email like, hey, I need a response to this by tomorrow. There's a statutory deadline. Great. It's not like I had anything else to do today that was just as important. So you want to make sure you're giving your partners in this enough time to review and get back to you. And don't be afraid to ask questions of your colleagues. Within Colorado, we have a very tight community of procurement officials. And so assuming it's not a confidential type situation, I'm picking up the phone and I'm calling my fellow procurement officials all the time to say, hey, what would you do in this situation? Have you seen this type of situation before? It can be scary to admit when we don't know something, and it's hard to get past that, but it's so important to get past that because you have a wealth of knowledge around you and use it. It'll make your life easier, and it may make their lives easier too. Don't panic. It can be very scary, especially the first time you see a protest, and you're like, oh no, something did go wrong. What am I going to do? It's okay. Take a pause. If you need to feel the panic, but then let it go, and dive into the file, dive into the facts. It can also be really easy, as I mentioned, to find other issues as you're researching. Don't worry about the questions that aren't raised in the protest. Don't leave your response to the last minute. We'll talk a little bit about this on the next slide, but we have very specific statutory deadlines when we have to respond to our protests. So we can't leave these things to the very last minute. And don't take it personally. Rarely is a vendor protesting because you're a terrible procurement official and how did you let this happen? They're, most of the time, trying to raise genuine issues and bring them to our attention. Again, it's really easy to take these things personally, to think, I did everything right, oh no, I am a terrible person, I'm terrible at my job. No, you're not. These things happen, and let's deal with the situation we have in front of us and just keep things moving.
So this is just a slide that kind of gives you a breakdown of the actual protest process. This is based on Colorado law. Again, you're going to want to go back and look at your statutes and your policies and see what your timeline looks like. For solicitation protests in Colorado, the protest from the aggrieved party has about 10 business days from when they knew or should have known that there was something to protest about. And then once that gets submitted, the procurement official is the one who answers the protest in Colorado. They have 10 business days to then respond to that protest. And then if the vendor wants to appeal that decision, they have 10 business days to do so. And then in the state of Colorado, appeals are given to my office of the Central Contracts Unit in the Office of State Controller, so that we have an appeals administrator who handles appeals separately from like the procurement officials. And she has 30 business days to handle those appeals. And in our state, a vendor can ask for a hearing during that appeal process. It's not mandatory, so we don't have to have it, and we don't have to offer it, but they can ask for one, and then we will give them the hearing. For contract or breach of contract process, which again we don't talk too much about, but we have this, you can submit the controversy to the procurement official, and then that procurement official has 20 business days to respond to it. And then that vendor or contractor has 20 business days to file an appeal. And then the length of time for an appeal decision depends on the controversy in Colorado, so we didn't kind of give you a timeline here, but that's generally how it goes for contractor breach protests. And one thing of note, I'm not sure how it operates in your states, but in Colorado, at any time during this process, an aggrieved party can file an appeal to the district court. That can happen at any point, but once it happens, that administrative process is closed, it is over, and then we deal with the issue in the district court. But they don't have to wait, they don't have to exhaust administrative remedies in Colorado in order to file that appeal at the district court level.
And one other note, so this timeline on the solicitation process is specifically for RFPs in Colorado. We didn't used to have a protest option for our documented quotes, so our smaller dollar solicitations. But on our last round of revisions a couple years ago to our procurement code, we recognized that as thresholds continue to raise, documented quotes are just as important as RFPs, and so we have added in a solicitation timeline or a protest timeline for documented quotes. That's only 3 days though, because they should be much more straightforward than an RFP. So when a vendor is going to submit a protest, by statute, these are the things that must be in the protest at a minimum. So they have to give their name and give an address. They have to appropriately identify the solicitation or the award or the contract that they are protesting. They can't just say, I'm protesting an RFP. Okay, that doesn't actually help me figure out what solicitation it is. I don't even know if it's at my agency. You have a clock that potentially starts. I need to get you to the right places. So you have to identify for us what solicitation or award or contract it is specifically that you're protesting. They have to give us a statement of those material issues. They can't just say there was a problem. Okay, I can't research that. I don't really know how to respond to that. So they have to specifically call out the material issues that are giving rise to the protest, or if they're protesting a contract, specifically describe the controversy that they're raising. And then if they want to add any exhibits or documents that are substantiating their protest, they want to include those if they reference them. They don't have to. If they just want to say, hey, you messed up on your scoring in these sections and describe, they can do that. They don't necessarily have to actually attach anything, but if they're gonna reference additional information or exhibits, they do have to include that with their submission. So a receipt of this information to me, as the procurement official, starts the clock on the protest, on that 10 business day response. If I have questions and I need help responding, either I'm working with my team or I'm reaching out directly to our contracting procurement attorney generals. Rarely am I going to reach out to Amanda's office in the central contracts unit for help, because that is where the appeal right lives. So it can introduce some conflict of interest or bias if I'm going to Amanda or Vanessa and saying, hey, help me respond to this now. So that's usually rarely why I will work with her office, because we didn't mention this earlier, but the appeal decision by statute is the power to respond to an appeal is actually given to the executive director of our Department of Personnel and Administration. Interestingly enough, the executive director can then delegate it. Thankfully, our executive directors have always been very smart and delegate that authority to our central contracts unit, because our executive directors, of course, don't know procurement law, contract law, or any of that, so it doesn't make sense for them to respond to it directly. So that delegation lives from the executive director to Amanda's office. Most of the time, I'm working directly with my team and the program on researching the issues, on reviewing the file. I helped review the file. I don't post or do a lot of the solicitations myself. My team does that, but just because I reviewed it before they posted it doesn't mean, again, I'm not doing my due diligence and looking at it again and looking at it through the lens of whatever it is that the vendor is raising. Assuming I reach the point where I'm ready to respond, this is what has to be by law in the response that I give out. So I need to restate the material issues or a description of the controversy so that it's very clear. Here is what I am responding to. I'm not just saying, nah, you're wrong, let's move on. However many issues they raise, those are the issues I'm responding to. We give a background of the process and a description of any of the relevant factual issues. So I'm not necessarily going to spend an entire page describing every step of the process if the issue they're raising doesn't have a lot to do with the process itself. I'll just give a paragraph, high level, here's our general process and we followed it. And then I'll get into if there are issues with the factors that we put in or whatever it is they're raising. If they are raising an issue with the process, then I'm spending a lot of time going line by line. Here is every single step we took. And then if I'm responding with any exhibits or anything to their protest or directly referencing their own exhibits, we want to have that all together in case they want to appeal. Assuming they do want to appeal, again, by statute, this is the information that they must have in their appeal. Again, they need to put their name and address. They need to still identify the right solicitation, because how is Vanessa going to know what she needs to reach out to the agency for to look at the file herself?
And we keep referencing Vanessa.
Oh,
She's
sorry.
our appeals administrator, or just the mythical Vanessa, I guess. But she is our appeals administrator.
Yes, yeah, sorry. Yeah, Vanessa is who has she's got the primary delegation from DPA's executive director, Amanda, and our chief procurement officer, Sherry, have backup delegations. And part of the reason why I'm doing a lot of the talking here is I was previously in Amanda's role, so I have backed up appeals as well as gotten agency protests. So I have a wide range of experience that, again, we'll get into some scenarios in a little bit to just give you an idea of what it is that you might run into. So Vanessa needs to know all this information. So she also then needs to see a statement of material issues that they're appealing from the protest. Importantly, They cannot bring up new issues in the appeal. Their appeal has to just be centered on the issues raised in the protest. I recently had a protest at my agency, and the protest itself was basically a paragraph long in an email. Not very long. There was a couple very easy issues for me to pull out and respond to. Their appeal was 13 pages long. So needless to say, again, we did the process right. I will tell you some stories where I did have to uphold some. But a lot of Vanessa's response was, you didn't raise this, you didn't raise this, you didn't raise this, you didn't raise this. I was confident even if they had, we could have responded appropriately, but because it wasn't raised in their paragraph protest, we didn't respond to it. We just told them it wasn't timely. They have to attach any copies of documents that they've previously submitted to me as the procurement official in responding to the protest. They have to include my decision on responding to the protest, and then any additional relevant information they want to make sure that Vanessa has as she is reviewing the appeal. And receiving this appeal starts her 30 business day clock to respond to the appeal. So one of the main reasons why the appeal time takes longer is because the protest response authority is delegated to the procurement officials, to the agency. I already have, or at least I should, have a lot of background on whatever solicitation is being protested. So I'm not starting from scratch when I'm getting the background and I'm getting the information. Vanessa is. She has no idea what's going on. So she has to start from the very beginning. We will provide her the copy of the procurement file to review in full. In some cases, depending on the issues, that might be enough. Assuming it's not, we're likely meeting with her, just answering her questions. We're not pleading our case of why, oh my gosh, no, they have no standing or whatever it is. It's just we're answering her questions so that she can gather the facts to respond appropriately. Because again, we really try to foster a culture in Colorado of not being afraid of an adverse decision on a protest or appeal against the agency. Because if we did something wrong, then we did something wrong, and we need to fix it. And that's okay. I know it can be really scary. So as Amanda mentioned, an aggrieved party may request a hearing on their specific appeal. So this is a very informal process. Whoever is the appeal administrator, again, in our case, it's Vanessa, she has a lot of control over this process. She really kind of gets to set the rules, set the standards for what is going to come in. So as mentioned in the statute, the executive director of our Department of Personnel Administration, or his designee, has discretion over any evidence that might even be presented. I got to observe some appeals early on before COVID, so they were in person. Now they mostly happen over Zoom. And in that case, the appeals administrator knew from what she was seeing from the aggrieved party that there wasn't really a lot of evidence that was going to happen, and anything that was going to be raised was irrelevant. So she limited the amount of evidence the aggrieved party could bring in, but still let him have his say. And that's really all that was needed in that hearing, was someone just needed to feel like someone else was hearing their problem. And she still upheld, or she denied the appeal, but it resolved a lot more amicably than we would have originally thought, because the aggrieved party was really mad. And then he got his hearing. He got to tell us all the things that were wrong. He got to feel like he was heard. And then we got to move on. So sometimes that might be what is required in a hearing. Again, it's a little harder now that a lot of it is virtual, that a lot of the meetings are through Zoom or on Google Meet, Microsoft Teams, whatever it is you use. So it's harder to kind of gauge where someone is at and what they might need. So I think now Vanessa does a lot more evidence type. It's a little bit more formal, the way she runs it. Some opening statements from both sides, all of those pieces. But she really gets to set those terms. She can just meet with one side and then the other, doesn't have to meet with them together. She can, again, require them to bring specific pieces of evidence, specific statements, whatever it is that she thinks she needs as the appeal administrator to make a ruling one way or the other. And she sets the time. So this hearing does have to fit in to the 30 business day clock. So obviously it would be a little unfair if she were to say, great, it's 29 days, let's have the hearing now, because clearly her decision's already decided at that point. And if I'm the aggrieved party, I'm like, well, now this is a waste of time and it's not fair. So she will always set them with enough time for her to reconsider anything that she does need to based off of that hearing.
And also, just to throw in there, I don't know about you guys in your states, if any of you deal with protests or appeals, but I have noticed, like this year, that there's been an increase in appeals, for sure, and that more of those appeals are also requesting hearings than previously did. So I don't know if you've noticed that or if that's a Colorado thing, but if you deal with appeals, like that might be something to keep an eye on in the next few years, because I think it's interesting to stay ahead of those trends. So.
And one thing to research in your statute as well, so again, it's a little different right now with it being over Zoom, and I think right now Vanessa is getting clarification from our AG on the public nature of the process, but pre-COVID, when everything was in person, these hearings were public. If somebody wanted to go and check out and watch, they could go check out and watch. So if your state has a similar public hearing process, whoever is your appeals administrator, I would connect with them and say, hey, can you let me know the next time you have a hearing that's coming up so I can go see kind of what's going on, so I can prepare. Again, we can do everything perfectly. That doesn't mean someone still might not protest an appeal. And so having background and having a really good understanding of the process is so valuable. So again, don't be afraid to reach out to your colleagues within your own state or in other states. If you ever are curious about how Colorado does things, always happy to share. I have in a short period of time, a wide range of experience. I've been at 6 different agencies. Again, one stint in the central contracting office. So we're always happy to chat and feel free to reach out. I think our emails are at the end in the app. So always feel free to send us an email. So once Vanessa has reached her decision, this is what has to be in her appeal response. So again, a lot of repetition, responding to or adding the name and the address of the aggrieved party. A lot of our statutes are being rewritten right now to take out the required physical address requirement, in some cases to just have an electronic means of communication, but as of now, everything still requires a physical address. She has to specifically identify the appropriate solicitation and the original protest decision. Because some vendors, I don't know about you all, but some vendors apply to a lot of different solicitations at a lot of different agencies. Hopefully they're not protesting every single agency, but they also need to make sure that they know what is specifically being responded to. Restating the material issues that are giving rise to the appeal. So this is the section where, as I mentioned in the recent one I had appealed, Vanessa laid out, here was your original material issue. Everything else, while it could have been material, is not timely. So it is not an issue that I am responding to in this appeal response. It is time barred. Again, copies of any of the documents and evidence that were submitted previously from the vendor and then myself that I included, and then giving her decision of either upholding the protest, denying the protest, in some cases upholding it in part, and then any action that might need to be taken as a result of that appeal. So the most common one we see in Colorado when a protest or appeal is upheld is part of the process or all of the solicitation process needs to be redone to cure the defect. By statute, this hasn't been tested in court yet. Hopefully we never reach that point. But by statute, the only remedy for a vendor that is protesting a solicitation
in
Colorado is their costs for putting their bid together. They don't get to automatically get the contract. They don't necessarily get to ask for additional costs it takes to do the appeal. Our statute specifically says their only remedy is costs for putting their original bid or response together. But again, most of the time, if we have done something wrong, we don't necessarily just want to give the money to the vendor to go away. We want to cure whatever it is that we did wrong and redo the competition fairly for everyone. Because if this vendor was right that something was unfair, then it was unfair for all of the vendors that put in their responses. And I don't think I've ever seen a case where we upheld a vendor's protest or appeal and said, we're going to redo it, no one's complained about that piece of it. Almost every case I've seen, the vendor's like, awesome, thank you, this is great. Make sure we communicate with everybody about when the new solicitation or the new evaluation is happening.
And that kind of goes back to what we said earlier about competition really being so important here. So you just want to make sure that everything's fair because and it goes back to what Keith was saying earlier, quite frankly, like this idea that we want to foster that competition. We want to get to make that available equally to everybody, but also because the state benefits from that robust competition. So that's why we make sure, at least like in Colorado, and why it's so important to take these seriously and fix your process rather than just deal with individual protests. Because like we win out when there's better competition and when we handle our competition better.
So just a quick slide on the contract disputes that we may see protests or appeals on.
Yeah, these are there's less common. In Colorado, we have contract disputes, but they're not necessarily handled like formally unless something goes very awry. But just to go through that quickly, usually if it's a big enough issue, the agency will bring it to our office, the Central Contracts Unit. And then or the AG, depending. Sometimes we'll bring it to the AG's office. And you're going to want to review the contract terms, obviously. Our state uses statewide templates for our contracts, so it feels very comfortable to think like, I know what's going on in every single term because I read these 100 times a day. No. Read it. They're going to have negotiated something, especially in a contract that made it to that dispute level. It was probably pretty heavily negotiated, even if you work with templates. So make sure you're looking at it. Make sure you're identifying the part of the contract that's at issue. Look at the termination dispute language that gets negotiated, especially at these high-risk contracts. Make sure that you are looking at the scope of work. A common issue, less common with high-risk contracts, but is that the scope or statement of work was not very detailed, and then you have to sort of deal with that, and that's why that's a whole different topic of having really good statements of work and scopes of work, but that can become its own issue if you have I've had one that was similar to that. It was a software contract. And it was pretty detailed, but not enough. And there was a pretty big dispute between the vendor and the agency about whether the vendor was actually meeting their requirements in this software. And the vendor, obviously the vendor thought they were, and it wasn't, it was pretty specific, but not enough to really decide. But that brought up a contract dispute. And then, you're gonna wanna do a debrief after and say, like, are we going to have to look at these SLAs? Are we going to have to look at these end user license agreements more closely? Is there a part of it that we didn't think was an issue that now is becoming an issue because you're seeing it more often in contract disputes? Did a certain SLA not really meet the needs of an agency, for example? So you can start thinking about that when you see these disputes, and it really helps you build your statements of work and scopes of work later so that you know that, like, okay, this is an issue. Let's be very specific and get our needs met when we do this in future. But yeah, so those can vary a lot more than maybe RFP protests and appeals. But just look at the contract, read it, and then have takeaways. I think a big part of this presentation is that you're not just dealing with these things individually. Like, you're gonna want to look at it and say, how can we make it better for the future? Like, is this an issue that we're seeing over and over again? Is it a change we have to make to our template? Maybe a change to how we process certain things? Is it an issue we're having when we do solicitations, and maybe we need to think about that? Process improvement is really important here, and it's something I think we really want to drive home, that this is a good thing. Like, because it's not good inherently, but it's good because it makes you better and makes your office work better.
Yeah, and one other note on contract disputes that definitely, again, at least in Colorado, does separate them a lot from the solicitation protests we see is there tends to be more opportunity, going back to the previous presentation we saw, there tends to be more opportunity for business decisions in resolving the dispute before it reaches a formal protest level. So an example that I just dealt with last week, we had a contractor who was giving us very, very subpar work. And we were originally working with them on getting it up to snuff, spending entirely too much state employee time getting it there, but it was a long-term relationship. We were trying to work with them on it, and then our state legislature took all the money away. So we had to terminate the contract for lack of funding. But there was still some outstanding deliverables and work that they felt like they should be paid for, that my program folks felt like they had not done well enough. And it reached the point where the vendor hadn't yet submitted a formal protest, but still submitted a formal letter saying, we met these deliverables in the statement of work, you owe us this money. And I met with the program and said, all right, we're at the crossroads here. It's gray enough that I think you could say, you met the bare minimum of the deliverable, here's your money, go away. They also, one of the deliverables was a presentation they were giving to one of their boards, and on the very first slide, there was a typo. That's not an adequate or acceptable delivery of that specific deliverable. So I said, we can still tell them, no, you did not give us what is specifically called out. You didn't give us a presentation that we can use. So I can now reach out to our AG partners and say, we do want to push back and we do want to fight this. I can stand up with a straight face and argue either way if anyone ever questions the decision. And that was the case because, again, as I know we're all experiencing, we don't have our federal partners here. My agency gets a lot of federal funding. There's a lot of funding issues right now. They had other things to worry about. They decided as a business decision it wasn't worth the fight. They had the money set to the side just in case. So we paid the vendor, told them, fine, good enough. Expect a post-contract evaluation from us that is going in the public file. We will talk again soon. So in contract disputes, there are a lot of off-ramps and a lot of areas where you can work with the disputing aggrieved party that you really don't have in most cases in a protest or a solicitation protest. In Colorado, the way that the kind of timeline can start for when the vendor has to protest is once the vendor or once the aggrieved party either knows or should have known the facts giving rise to the issue. So we've had cases where, and again, this just happened to another agency in Colorado recently, where the solicitation was posted. It was still within the time frame for responses. And a vendor protested the solicitation at that point and said, this requirement that you've put in here is inappropriate and is unfairly biased to another specific vendor. So in that case, I know my fellow procurement official looked at it, agreed after a second review, but had the time to amend the solicitation and then just extend the time for all the vendors to respond. Rarely do we see a protest at that time. It's usually after the whole process is over, and we can't make those in the moment pivots at that point. So it's either we're upholding and going back and starting at least one part of the process all over, or in one of the examples I've got coming up, we canceled the whole solicitation and pivoted to a different procurement path. So next up, we have some protest scenarios I want to talk through. I was going to say before that point,
yes.
Are there any questions?
Indeed. So first, could you expand when a decision to uphold a protest in part rather than in total may be more appropriate rather than the total cancellation of a solicitation or award?
Yeah, so that can depend on what remedy the contract or the aggrieved party may be asking for. Again, monetarily, their only remedy is getting their costs, but sometimes they will ask for, you should just redo this whole entire process. And in some of those cases, it's, you know what, we agree that there was an issue here, but like if, let's say it went to appeal. Vanessa may say, I'm not gonna make the agency redo the whole solicitation start to finish, but I am going to make them redo the evaluation part of it, is usually where we see those kind of like uphold in part, or if there were multiple issues that were raised, we could say, yep, I am upholding these 2 issues and denying these 4, but these 2 alone were enough to say, yep, we got to redo the whole thing. I hope that answered it. If not, again, you're never going to hurt my feelings if you say that did not answer my questions. Please try again.
Yes. Are there any other questions? Yes. Yeah, you can, those mics, you can actually pick them up and move them. They don't have to stay where they are, so.
Thank
is that
you.
a
Thank you. So did I understand you right? You said that you do a post-contract survey or something along those lines that you put into the procurement file?
So no, we don't really do a procurement. Well, I can't say currently we don't do procurement surveys. When you say survey, though.
Well, I wasn't sure if you meant survey or if it's the post-contract, you said like a,
Oh, yes, what I just mentioned. Yes. So at my agency, because we also do a lot of grants at my agency, we have a very formal contract monitoring process, and as part of that process, every grantee and subrecipient, we do the program does an evaluation of the services that
Okay.
we got, and we send it to the subrecipient to say, here is our evaluation of you. 99% of the time, they're standard. If a program wants to give, I'm veering a little bit of a tangent, but if a program wants to give an above average grade or a below standard grade, then that has to come to a member of my team for us to review to say, okay, you didn't like them, but they did actually give you what you needed, so you can't just say, I don't like you, you get a below standard grade.
okay, so, but I thought when you were talking, you said that if you had a protest, you may end up granting the protest to some degree and then, but reflecting that into the post.
That was, I think,
Contract.
that was in relation to the contract dispute issue. And so what she was getting at was the idea that, like, in a contract dispute, you can have those disputes, you can work it out, you can then decide, let's say we're going to accept your deliverable and pay you. But then when they do that post delivery survey or whatever, whatever you call it, what do you call it?
Yeah, so it's a contractor evaluation. That's not part of the formal protest process. We would never, like if a vendor protests, we would never say, great, you're a terrible vendor. We would not do that.
I mean,
Sorry.
That's what it's getting at. In my
Oh,
mind, I
yes.
was thinking,
No.
or have you been accused of retaliating?
Yeah.
You
No,
filed
no.
a protest, but we're going to, slip a.
Yeah, no, it's just very much that's here is how you performed as a subrecipient.
Right.
And in that case, if they went to formal protest, those would be two very, very separate things. But no, we would never evaluate a vendor and say, hey, you're terrible because you protested us. Thank you for asking that. It's a great clarification.
Thank you.
Yes.
More questions? Yes. Can you use the microphone, please? Thank you.
This is going back to the early part of your presentation about the aggrieved parties and the definition of an aggrieved party. How would a prospective bidder have standing to protest?
So this could go back to, I think, some of the examples we heard from Keith this morning of if there were kind of restrictive, factors written into the solicitation of saying, we will not accept a limitation of liability. And then we accept a limitation of liability. A vendor that didn't bid could have bid but for that piece, so they can protest and say, you were not transparent in your process. Because in our procurement code, we cannot, in an RFP, negotiate on our factors and anything we say that is a mandatory minimum. We can't negotiate those things. So then if a vendor saw, great, if I need a limitation of liability and they're not going to accept it, I'm not going to put my time into a bid, and then see a contract come out of that solicitation and see a limitation of liability. They are a prospective vendor, so they could have been a vendor and actually responded, not just, it's an IT contract, I pour concrete, I'm going to protest it. Like, you're not a prospective vendor in that case. But so that might be a scenario where somebody that isn't an actual vendor but could have been can raise a protest. Yeah.
More questions?
So great.
I know protest is an area where you states, for good or for ill, are quite different. And so having someone with a robust process like Colorado does, I think, is a good example of all the different things that can be included. But if anyone wants to share some differences in your protest process or, some interesting things you noted, please do so. Some of you don't even have one. Cough, cough, South Dakota, cough. Okay, you guys continue with your scenarios. If you guys have questions, just raise your hand.
All right, so these are just some example scenarios that I'll go through of ones that either I've received personally or I've seen personally, but they also tend to be the most common. So discrepancies in scoring, especially if you use numerical scoring, and that scoring tends to tie to comments that hopefully everybody gets their evaluators to provide. So if there's a comment that says, this vendor is awesome, and they scored a 1, I have questions as a vendor. If there is any issues or discrepancies in the process, if there's any potential bias in the process. Again, going back to those comments or any of the proposal documents. So if the comments from an evaluator say, yep, the winning vendor had a really thorough project plan, so I'm scoring them a 10, and the proposal from this winning vendor, the project plan is 2 sentences, those things don't really line up. And again, I have questions if I'm a losing vendor. Concerns about the winning offerer, the winning vendor, and whether they could do the work. Not saying that's a valid reason to protest, but I've seen those protests from some of our vendors. And then surprise issues that you could never anticipate. This is, again, examples of ones that I've seen. So dear procurement official, vendor submits this protest to solicitation number on the basis that evaluator 1 has a clear personal relationship with an individual who works with the winning vendor in a critical capacity. It's not just I'm best friends with somebody that is the hired out janitor. It's, oh no, this evaluator is best friends with the vice president. I'm gonna ask on some of these some prompt questions. I did teach college for a little bit of time, so I'm not afraid of uncomfortable silences, but if nobody wants to raise their hand and jump in, I'll just keep going on. But I do wanna give a moment for some discussion. So when you were to receive a protest like this, what would your kind of first step be here? And there's no wrong answers.
Really?
No, it's good. After lunch, we're all still waking up. Oh yeah.
Hey.
In the state of Nebraska, we would respond, please refer to our protest policy, because they have to allege like the actual grounds from our policy, just so then any vendor or the potential awardee can, they know exactly what's being protested. I mean, in this case, it would be clearly biased, but we make them do that in writing, so
Okay.
then they can't come back and say, well, we were trying to communicate other reasons beyond that.
Yep. No, that's great. Colorado, it's a little broader. They don't necessarily have to explicitly call out bias, which again, I think works. It's a pro and a con. If I see this, I'm gonna respond to, here's bias. They may in their appeal try to say, no, I meant this. At least as of now, and it hasn't been challenged, our appeal is going based off of how I responded and interpreted it. Any other thoughts on what your first step might be here?
You know, I don't see any actual harm mentioned in this statement.
Yep. No, that's a good call out of, okay,
So what?
they're best friends, who cares?
Yeah.
And that's a lot of times that's kind of the perspective that some folks will take, and I think could be a valid response. So I'm gonna now jump ahead, because I think we were ahead of time and now we're behind, which is great. I am not complaining. I was worried about going too fast. So in this case, I don't necessarily, after reviewing all of the facts and reviewing everything that was attached, I don't think that there was necessarily any real harm. This evaluator, I do think, truly was unbiased in her review. But because the appearance of bias here was just so blatant, there were literally emails between this evaluator and the vice president of the winning vendor making Christmas plans. What we decided was we did uphold the protest, and we redid the evaluation with brand new evaluators. The result ended up being the same. The winning vendor still won, but because the appearance of bias just was so bad and so extreme, even though we truly think the evaluator was objective, after investigating and talking to the evaluator, and the evaluator herself said, oh yeah, I am best friends with that person. I didn't disclose it because I didn't think it was a problem. So that also led us to rewriting, this is at a different agency when I was there, rewriting our conflict of interest policies and documents saying, even if you don't think it's a problem, if you have any relationship with any of the vendors that submitted, you have to disclose it. So that was kind of the outcome of there. We found deficiencies with our own processes and policies around conflict of interest. This is a protest I received on discrepancies in scoring. So the vendor submitted their protest and said that there was bias or that there was inappropriate inclusion of information that wasn't contained in the solicitation. So and this is one, just jumping ahead, I did uphold this one. I went back and I looked at our processes, and yeah, what we wrote in the solicitation document of here is what we're grading on versus what we wrote in the evaluation documents, they weren't a very clear one-to-one match. And so again, I could have said, well, they're close enough, like they're in the same vein. That's not good enough if we want our vendors to trust the process. And this is one vendor, the losing vendor that protested, was very upset. Like, it was a very strong email that they sent with their protest. And then when I responded and said, I am upholding the protest, we're gonna redo the evaluation, they came back and said, that's great, thank you so much. And then I sent an email to all of the other vendors that submitted and said, hey, we discovered discrepancies in our processes, we're canceling the award, we're redoing the evaluation. And I had other vendors that didn't protest respond and say, hey, that's awesome. Thank you so much for letting us know, and thank you for redoing the process in a way that's fair. And so again, just because you get a protest that is valid and you have to uphold it, you're potentially building better relationships with your vendor communities. Your agencies are building those relationships and instilling more trust in the process. So another one I received was a vendor protested based off of their interpretation that the winning vendor didn't have the right qualifications, and that we as the state were getting ourselves into an area of high risk if we went forward with the winning vendor and contract with them. This is one we reviewed. And again, this could be an easy one to say, well, that's our decision to make. We get to decide what level of risk we as the state are going to accept. I didn't start there. I said, okay, let's review the solicitation, let's review the winning protest, and make sure that they did meet our minimum requirements and that the scores and the comments made sense. This really did, so this was around PFAS cleanup. So if you're not in the environmental space, PFAS is the residue that comes from things like fire extinguishers. That's toxic material, that's hazardous waste. We have to destroy that material very specifically. And the winning vendor in this case had a very innovative process. So it's been tested, but it's still very new. But it met all of our requirements to a very high standard. And so ultimately I did deny the protest and say, they met all of our standards, they reached these points, here are the comments that support it. I'm denying the protest on these grounds. But it would have been easy to just start off and say, you don't get to tell me what's acceptable risk. I get to tell me. Amanda's office gets to tell me what's acceptable risk. You don't. But again, I didn't start there. I didn't take it personally. My purchasing agent who ran the solicitation didn't take it personally. We met with the program. We went over all of these things and then came to the conclusion that no, the winning vendor did deserve to win, and we're going forward. This is also the same vendor I mentioned earlier who then appealed. So their original protest was about a paragraph long. Their appeal was 18 pages, or 13 pages. That part was denied. So here are some surprise issues that I have gotten to experience in the protests I've seen. So I had one vendor protest saying that one of the key factors in the winning vendor getting the award was the key personnel that they brought to the interviews used to work for the losing vendor and had a non-compete in this space with the losing vendor and were now working for the winning vendor. I was a month into being a procurement official when I received this one. So this is one, again, especially being so green, I wasn't afraid to go to other people and say, this doesn't seem like my problem, but I don't know. And so I did a lot of research. I talked with our AG, I talked with some other procurement officials, and ultimately the answer was, that is a you problem. You guys need to go fight that out somewhere else. We did everything right. We followed our process. I'm denying the protest. You guys go have fun. That's definitely, I don't want to get in the middle of. We had another one that seemed very straightforward initially, where a vendor said that there was bias in the process. They submitted an email saying that this email, which again was written a little bit where you could see there might be some bias, my purchasing agent was trying to say to the evaluators, If your comments don't match your scores, then something needs to change. The way it could be interpreted is you need to change your scores so this person wins. The issue here is the vendor that was protesting had not Cora requested or done a Colorado Open Records Act for any documents. So they were getting this internal email from somewhere. So they were clearly communicating with our evaluation committee in a way that looked very inappropriate. I researched it, could not find how that vendor got that email. They did not want to share. So I ultimately decided there is a problem here with the process. And if there's not, I can't get the evidence to say that the process did get done correctly. So I canceled the whole solicitation, and we ended up moving to a price agreement vendor from one of our NASPO price agreements, because time was of the essence. We had to move on. So I don't think anybody really won in that situation. But again, I was able to take what I found and work with my own purchasing agent and say, hey, this email definitely comes across as wrong and inappropriate. How can we fix it?
Not so subtle NASPO price agreement plug.
Yes. Trying to be subtle, but absolutely failing. So last couple things, takeaways. Don't be afraid of protests. They're not a bad thing. If you did everything right, you're going to be fine. If you didn't, you need to know that. We want our clients, our programs, our state constituents to trust the procurement process. Know the process. If you don't, go find where your procurement process lives within your statute or rules. Be thorough, review the entire file, even if you think it might be something really easy. And don't be afraid to ask for help when you need it. You don't have to know all the things. And really just approach it like any dispute you would as an attorney.
All right.
And that's
Thank you,
it.
guys.